So, good morning everyone, and welcome to our colloquy for week 2. This is the session that is being recorded in Toowoomba. Just a few admin stuff. Now we can confirm that your, first of all, exam is going to be an open book exam. So if you go to the specs for this course online, you'll find that all the specs, regardless of which offer it is, whether it is on campus in Toowoomba, on campus in Springfield, or online, they all have the same structure for the assessments. And the exam is going to be an open book exam. Let's start with the assessments though. So now everybody has to do the second online test. There is no 10 marks for tutorial participation for people on campus. Okay? This is good for you because it means that you have more flexibility. You know, in the past, people, especially people who work, for example, or if you have different subjects and clashes with your assignments or assessments, and they would say, oh, I'm sorry, I missed this tutorial. Can I make up another one? And so on and so forth. Now you don't have to worry about that. Everyone, whether you are online or on campus, you will have to do the online tests. So they're really quizzes, you know. They're actually the simplest, easiest part of this course. And you're going to get a final exam, and the final exam is going to be an open book exam. Yesterday, someone actually put something on the forums asking, what does that mean, open book? Well, it means that you can bring, and there's a definition on the USQ website, but basically it means you can bring anything that's written, okay? Whether you print it out or you handwrite it, that you can admit, you can bring in, okay? You cannot bring in anything that's electronic. I would allow you to bring anything in, but remember, this is all evolutionary in nature. 50 years ago, if you told someone we're going to have an open book exam for low courses to go, you know. But we have changed. We have changed our way of doing education, our way of learning. We know what we need from you, and it's not, you know, memorizing things, because you're not going to do so in the real life. I would admit everything, including even, you know, tablets or e-books or even access to the internet. Why not? But for now, 2017, that's what you get. Only things that are in writing, things that are printed out. So you can bring in your book. You can bring in, for example, your tutorial question and answers. You can bring in your own answers to previous exams, so multiple choice questions, because let's just talk quickly about the final exam. The final exam is going to be 2 parts. So the first part is going to be multiple choices, 15 questions, each worth 1 mark. And I can tell you now that these questions are going to be very similar to the ones that we issued for the last exam, which is the one for semester 3 in 2016. Not the last exam for semester 1. So if we go to study desk, so this is, I think, what you see, and at the bottom there you'll find that you have these previous exams. Okay, so I suggest that you, especially for purposes of the first part and the second actually, make sure that you go through these exams, especially the first one, which is the one from semester 3, 2016. So your multiple choice questions for this semester are going to be, some of those questions you find there will be repeating this semester. All right, so I think that's enough. Any questions about what you need to do? Are we all clear about how this is going to work? Yes?
On the actual study desk or whatever, with your written assessment, it says it's on the 19th. It says the 18th.
So what you need to look at, let's look at the assessments tab. and it says that your written assignment is going to be due on the 18th of August. Where did you find that September thing?
In quizzes. It's got online tests, written assignment, and online tests.
So on study desk?
Yeah.
So maybe you can show me afterwards, just offline. So this is the official due dates table. So the first test is going to be due on the 4th of August, then the assignment on the 18th. And then the online test 2 is going to be way back till the 20th of October, and then the final exam. In relation, any questions online? Anyone online? Questions? Is it Chloe? Chloe? If you can mute your mic, I would appreciate it. Thanks. So, any other questions that you have? Yes?
You said we're going to start talking about the written assignment in the tutorial.
Yeah. In relation to that, there will be something called a formative assessment, as opposed to a summative assessment, which means that I'd be happy for you to email me a draft of your assignment, and I'm going to actually discuss it with you, not necessarily mark it in that sense, but discuss it with you so that you can improve on it, and then you can take this feedback and integrate it into your draft and then submit for marking. That would be your summative assessment. We'll talk more about that, but really, be reasonable. If you come to me on the, I don't know what the 18th is, but if you come on the 15th, 16th, I'm still happy to look at it. Anytime before that's fine, but if you come to me on the 17th or the 18th and say, I want you to look at it today, it's a bit too hard for me to fit into my schedule. Just be cognizant of that, just be reasonable. All right. Again, the reason why this is happening, and it wasn't easy, is because of this thing called My Opinion Survey. I will give you hopefully a survey midway through the semester. So at end of week 5, again, if you have any things that you need to be done while we're going through the course, let me know, okay? But it's a great improvement year on year. All right. So now we're going to start our colloquy for today, and we're going to talk about one chapter, only half of that chapter actually, because this chapter is relevant to your assignment. So it's important that we go through it slower than the historical material we did last week. As always, I remind you, this is from your specs, that in order for you to succeed in this course, you need, especially the one in the middle there, the third bullet, to demonstrate introductory level critical legal thinking skills. So the first opportunity for you to demonstrate that is going to be the assignment. And as we said, in order for you to demonstrate that legal skill, critical thinking skill, you need to go through this menu of identifying the legal issues and so on. Okay, let's then get started on chapter 4. And as I said, all I do in the colloquies is to have a discussion with you. So we're just covering the summary rather than go through the lecture recording that's already available to you on Study Desk. So you go to Useful Links. Under Useful Links course recordings, you'll find that you have the recordings for all the chapters we're going to be covering this semester. All right. Let's start talking about these Latin terms. The first is what's known as ratio decidendi, or sometimes pronounced ratio decidendi, and obiter dictum. Okay? And obiter dictum. The first one is Latin for the reason of the decision. ratio means reason. And decidendi is decision. Okay? Something like the reason for the decision. So this is in relation to a court ruling. When a court decides a case, they will have to decide it based on a reason. Why? And then the decision that comes with that reason. Basically, who wins and how much they get and so on. Now, if you go and look at the reports of any case, you will never find the words ratio, decidendi in that report. Nor will you find something like a title or subtitle telling you the ratio. Okay? So this is what lawyers and jurists do. It's your job to actually analyze the decision post-judgment and be able to abstract from the decision that is in the case, which we call res adjudicata. That's what you're going to find in the case. Again, you're not going to find something that says the res adjudicata is, but that is basically what the court is going to come out and say, this party wins, and this party wins because of so and so. But they're talking about the specific facts, the specific material facts in that case. Your job as a jurist or an analyst later on is to see how that would be applied as a principle, i.e. to a larger area of the law. Now there's also something called obiter dictum. So saying by the way. Again, you'll never find anything in any, well, never is never, so sometimes you might find something and you can tell me, oh look, it says obiter dictum. Usually you will not find any reference to neither of these two, to either of these two in the judgment. You'll only get something like, if the facts were so and so, so these are not the facts, and we know that's not the facts, but this is the judges. If the facts were so and so, then the outcome would be so and so. So they're talking about a hypothetical or a scenario. And that's what we mean by obiter dictum. So the best way to understand this is to go through an example. Okay? So we're going to talk about Headley Burn, which is on page 92 of your textbook, the 9th edition, page 92. Now before I go through that, I just remembered something that I really need to make sure that you are following through, and this is in relation to your assessments. I said last week I need you all to go ahead and print out excuse me, your assessments. Okay, so that's exactly what I've done here. You should have now your online test 1, so you have to print it out, something like this. So you have all the questions, and you can go ahead and read them one a day, slowly, and try to answer them as we go through the content. Okay, and the same thing applies to your online test 2, and as well as to your assignment. So you need to find the template, which is just under that due date table on the assessment tab. And I want you to cut and copy. You have to be careful reading through your rubric. So this is what we call the rubric. And that's what the marker, I'm not going to mark these, that's what the marker is going to look at to decide what you should get. So now, by now, you should have your both scenarios cut and paste into your file, and this is the file they're going to use to write your 400 words for every scenario, and then submit this online. Okay? Please make sure that all of this is now with you, and you're ready to start working on from today. There's also a required reading. Okay? There's a required reading, and this reading is available in the resources tab, and this reading is needed for your assignment. So this is the one called alternative methods of dispute resolution. Okay, we're going to summarize it in the tutorial. But you need it, and you need to read it and refer to it in your answer to the assignment. All right. So let's go back to Headley Burn, and let's look at first what we have in the textbook. Okay, so Headley Burn comes to us from the United Kingdom. It's a case from 1964 from the appellate courts, and it was decided by the House of Lords. The facts. It says the appellants were advertising agents and the respondents were merchant bankers. Who are the appellants? What's their name? From the name of this case, who are the appellants? That's correct. Someone said Headley Burn. So the first name given to you is your appellant, and the second name is your respondents. The appellants had been asked to place substantial forward orders for advertising on a company called Easy Power. Okay? On Easy Power's behalf. And they asked their banker to ask Easy Power's bankers about their creditworthiness. So they want to actually give them the advertising campaign before it's paid for, so it goes out quickly, but they want to make sure that this company can pay. The respondents replied that they considered Easy Power financially stable. Although, and that's the important point here, at the top of the letter, the banker's letter, they stipulated, so they said that the statement, i.e. the statement that this company is financially stable, was made without responsibility on the part of the bank or its officials. So I came to you, I asked you, can you please tell me whether this company is financially sound? And you said, yes, it is. But I owe you no responsibility. So you want to take my advice? It's up to you. So the advertisers relied on this reference, relied on this letter. And they placed the orders for advertising. The appellants assumed responsibility for the payment for this advertising in expectation that Easy Power is going to pay them back. But it turns out that the company ended up going into liquidation, which means that they ceased to operate, which means that they cannot pay you anything. So there are creditors, other creditors, and they will probably get any assets liquidated, and then you will end up getting nothing. At the end of all of this, our appellants ended up with losing $34,000. So these are the facts. If this was an assignment, an exam question in part B, this would be the question. You are given a set of facts. And your job is to figure out, what is the legal issue. Here it's given to you. as we will learn more when we look at contracts and the content of contracts, the issue here was about something called an exclusion clause. Now, the exclusion clause is basically this highlighted part there. The exclusion clause in the letter was this statement. Okay? Excluding what? Excluding responsibility. For what? For our statement. Which statement? That Easy Power is financially sound. So the issue was, did this clause protect the bank from liability? Was it effective? Did the bank or the person requesting the information a duty to take care when they knew the requester would rely on their financial advice? And the decision was basically the respondents were not liable. So the bankers were not liable because, and this is the ratio, the decision was what? They were not liable. So the exclusion clause is effective. Why? Because the clause inserted by the bankers to take no responsibility for any advice that they may have given was adequate rather to exclude the assumption by them of any legal duty of care. And thus, an action in negligence was excluded as well. So we remember, we said negligence, and we'll talk about negligence more next week. No, not next week, the week after. We said that negligence has 3 elements. And the first one is always what? The existence of a duty of care. Our appellants here, the advertising agents, failed on this first element. Why did they fail on this element? Because the court said this exclusion clause that you knew was there, but you still decided to take this advice, was enough to exclude this duty of care that otherwise would be found for you against the bank. So this is what brings us to we're looking at this because we want to look at the difference between ratio decidendi and obiter dictum. So we just looked at the ratio. Yeah? The ratio is based on the facts that we have. However, so here in the case reflection, it says, where the references to the bank being liable for its negligent misstatements by the court, obiter dictum. So it says in the comments, the case is probably better known for what the judges in the House of Lords said about liability for negligent misstatements than for the actual decision, the res judicata itself, and is a good illustration of the effectiveness of a properly drafted exemption or exclusion clause. They were unanimous in saying that the bank would have been liable for this negligent misstatement if it had not put such a clause in its reference. So here we have a negligent misstatement. The bank was negligent, but they can get away with it. Why? Because they put that exclusion clause. So the court said the bank would have been liable if it had not put such a clause into this letter or into its reference. Is this what happened? In actual fact, based on the facts in this case, is that what happened? Did the bank put a clause in the reference or not? Yes. So what are they talking about here? They're saying in the alternative, had they not done so, they would be negligent. And then these advertisers could sue them in negligence and get monetary compensation. Is that what they can do in this case? No. So we're talking about what? A hypothetical. That's not what happened in this case. In this case, there was a reference, and the reference had an exclusion clause. But they're saying if they didn't put this exclusion clause, then they would be able to sue in negligent misstatement. Is this good for anyone? How are you going to use this? Well, you use it next time. So next time, when someone comes and says, oh, look, this bank gave me this statement, the first thing you do is to look, is there this exclusion clause or not? No. Aha, I now can use this statement. You understand? Not for this case, if something like this happens later on. So obiter dicta are useful, but not for this case, for a different set of facts. You can come and say, of course, this is from the UK, today in our jurisdiction in Australia, this would be what? Would this be binding? What do you think? Anyone? What did we say about jurisdictions? When you have a binding precedent, it comes from where?
Well, the state.
From the same state or from the same hierarchy? Is this the same hierarchy as we have in Australia? This is from the UK. So at best, it would be persuasive, but not binding. Okay. All right. Let's then go back and use our analysis. Based on the Wentworth-Miller method. So the first thing is we look at the parties. This is your planning. This is what you do in your head. Who are the parties? Again, it's the advertising agents, HB, Hedley-Byrne, and HMP, the merchant bankers. What are their objectives? Okay. Advertisers lost $34,000. So they want to be compensated for that loss. No more, no less. What do the bankers want? They don't want to be liable. They don't want to pay for it. Okay. Premises. Something called negligent misstatement. Of course, this is what you will hopefully be able to identify at the end of our course. So when we go through the revisions after the break. This is negligent misstatement on page 173. And the other one, they are relying on negligent misstatement, and the respondents are relying on their exclusion clause. The ratio that the bankers are not liable because the exclusion clause was valid in excluding any duty of care in negligence on their part. The arbiter that the bankers would have been liable for its negligent statements if it had not put such a clause in its reference. Yes? Anyone online? Hello? Corey? Corey? You want to say something? Can you hear me? All right, mate, I just have to... You want to say something? Okay, so that's fine then. All right. Braden, you want to say something? Okay, we know that you are there, so I'll always keep coming back to you, and hopefully during the break maybe we can also have a chat, all right? Okay. Okay, let's then move on to our next point. So, we want to go back and talk about the doctrine of precedent. Who can explain to me again, what do we mean by doctrine? We made the three distinctions. We said that we have rules, we have principles, and we have doctrines. What did we say about doctrines? Why do we call it doctrine of precedent? So we said rules apply to a very small area of the law, like traffic rules. We said principles apply to a larger area, and they are based on legal theories, on jurisprudence. And we said that doctrines are principles but have been developed over a long period of time and mostly accepted through the court system. Of course, the doctrine of precedent is the very mechanism through how we can develop our law through the courts. Okay? And we said basically it says that once a legal principle is established through a decision in a case, further cases with similar facts will be decided according to the same legal principle. So what was the legal principle in Hadley-Byrne, you think? Where would you find the legal principle in this summary? Another word for legal principle here would be, sorry? The premises, yeah. But what was the legal principle that I could use for my precedent? The ratio, thank you. So if this were in Australia, let's say that this is a case decided in the High Court of Australia, and that was the ratio, then that becomes binding on any other courts in that hierarchy that are presented with the same set or similar facts. So the principle here, the legal principle, is the ratio. So you see what the principle is saying? A party, so you have to abstract. A party is not liable in negligent misstatement if they have an exclusion clause, a valid exclusion clause. Something like that. That's the legal principle. And that's what you could apply again using the doctrine of precedent. Okay? That's what we mean by precedent. Hadley-Byrne did not find for these poor advertisers, but it opened the door for the ability of other people later on to sue in what we call negligent misstatement. We'll cover that in much more detail later on. For now, I just need you to understand the difference between ratio and arbiter and how ratio, if it's binding, becomes your precedent. Let's look at another case, which is where? Page 107. So let's look at that in your textbook. It says re Warimungu Land Claim ex parte Attorney General of the Northern Territory. This is the Australian Law Reports from 1988. The decision was by the full court of the Federal Court of Australia. Why does it say re? What kind of a name is that? Why would you start with the name re and then Warimungu? Yes?
Well, could there have been a case before this that was sort of the same, but it probably didn't succeed, and so they're trying again? I have no idea.
Anyone?
It's because it's for a large group of people. They're actually doing it for their cultural tribe, so it's not one person that's doing it. So it's like the representative of that group.
Not quite.
Okay.
So the thing is, when you have a case, you'll have two parties or more, and they all appear. They all appear in court. Here, one of the parties did not appear. Okay, so it becomes re Warimungu. That's not important. It's all right. Where was it decided?
Full court of the Federal Court of Australia.
Full court of the Federal Court of Australia. How high is this court in the land?
The highest?
The highest, but
Not the highest.
one. So what comes higher than the full court of the Federal Court?
The High Court?
The High Court. So you have the High Court at the top, and then you have the full court of the Federal Court. All right. So again, there's an act, as always. The Aboriginal Land Rights Northern Territory Act of 1976. This act allows Aboriginal land councils to make claims over certain areas of land, but excluded roads over which the public had a right of way. And that was done in sections 11 and 12. So Aboriginal people can make claims to land, but not if the land has these roads. Why? Because they have to be public access. Okay? This council, the Warramungu Aboriginal Land Council, made a claim under this act over land which contained stock routes. The devil is where? In the details. Stock routes. What is a stock route? It's a route where sheep and cattle can be moved from place to place by stockmen and can feed along the way. You see where we're going? What is the problem now? What is the tension?
The routes were under Aboriginal land. People were on.
No. Where is the tension now between this idea of stock route and what's said in the act?
Well, they seem to.
Sorry?
So they seem to be unrelated, but no, let her.
Okay.
Stock route is not a road.
Uh-huh. So now we're going to see the tension between whether the stock route is caught by sections 11 and 12. What turns? If it's caught, what happens next? Can you still claim that land? No, because the act tells you that there's this proviso if there are roads, excluded roads over which public had a right of way. So the question now, what about this stock route? All right. The legislation did not mention stock routes. And in the minister's second reading speech, what is the second reading speech? Has anyone looked at how we pass legislation in Parliament? What do we do when we want to pass legislation? The responsible minister is going to do what? Sorry? Put forward the bill, and by doing what? They have to do what? They have to do a first reading. So there's a speech by the minister explaining what's going on. And what happens after that? There would be the second speech, and this means that we are now getting closer to passing this bill. Sometimes they will send it to certain committees, they will talk about it, agree on certain things, and then it comes back to the second reading. The third reading is just rubber stamping. It's just a routine. It's the second reading. So you expect that if there are issues, something that could help us understand or how to interpret this act, we can look at this second reading. That's what we call extrinsic evidence. It's not in the act, but it was leading up to the act, to the bill itself. In this reading, the minister referred only to, and they quote, roads from the speech, roads over which the public has a right of way. Okay? And name the roads to which he was referring. So, there is an issue, yes? And it says, could the government reject the claim, arguing, and we are arguing about what? Are we arguing about the law, or are we arguing about the facts? Facts. And which fact are we really arguing about? Stock routes and whether there are roads. So again, here it says, arguing that a stock route fell within the meaning of sections 11 and 12. So what does the government want to do? See? They want to reject the claim. So I want to make sure that this stock route is going to go under this section 11 and 12, which means it's a road. I cannot, that prohibits me or excludes the ability of this council to get these lands as Aboriginal lands. Okay. That's what you need to identify every time you read a set of facts. Again, the decision here was that the Land Council argument that the court should take into account the minister's second reading speech was appropriate in order to determine the correct interpretation of the act. Today in Australia we have a set of acts called the Acts Interpretation Acts, including one for the Commonwealth, and we always look at the purpose of the legislation. Meaning, we look at the reason. Why did we pass this act? Why is this prohibited, for example, when they prohibit these roads? What is the purpose? In fact, if you're so inclined, you'll find that it's the same thing that some schools of thought think about religion. So the idea is that religion is nothing more than this ability to understand why or the reason behind something being prohibited or something being permitted or something that's being advocated for. So these acts, interpretation acts, allow us to use extrinsic material such as speeches from Parliament and use that to understand the purpose or the reason for what was said in these sections, for example. Let's look at the reflection. So the land claim could not be rejected on the basis of those sections. So what did the court say? Is a stock route the same as a road for public access? Yes or no? What did they say?
No.
No. And because they are not roads of public access, then they are not caught under sections 11 and 12. And they are not caught under sections 11 and 12, then they are not excluded. And if they are not excluded, then the council could make the claim on this land. Yes? Case reflection. Given the importance of stock routes in rural Australia, are we in rural Australia in Toowoomba?
I come from rural Australia.
Which is how far from here? 10 hours. So you don't think that Toowoomba is part of rural Australia? Okay. All right. Let's say that these routes are in fact important. Do you agree that these routes are important for rural Australia?
Yes.
Yes?
Yes, they are.
Okay. Okay. Do you think then omission in the minister's second speech, the minister did not refer to them? The minister comes from where? Which government? Northern Territory. Do they have rural Australia and Northern Territory?
Yes.
So do you think the minister's omission of these routes was an oversight that the court should have corrected? So basically they're asking you, do you agree with the court or you disagree with their decision? What do you think?
Well, we disagree because you said they didn't approve of the stock route, so we should disagree with them, right?
No, but this is what we call the alternative, the hypothetical, okay? The counterfactual. What happened in this case is that the court said the minister did not identify these routes as part of the routes he was talking about in his second speech, so they are not caught by sections 11 and 12. Is that the reasoning that the court should have followed, or should they actually have gone beyond the speech and said, even though the minister does not refer to these routes are very important for rural Australia. So you can't just come and take them and make them just Aboriginal land. You know, you have to still keep them within the general populace. So you cannot actually take them away, which means that they have to be caught by these sections, which means that the council cannot claim the land. Do you agree that that's what they should have done? Why? So this is the word that they don't like to hear always, you know. But as someone who's doing legal analysis, and even for religion in that matter, you have to ask always why. God says so, why? So why do you think God, I mean the courts in this case, said that that's how it should be? That we're not going to go beyond the minister's speech. What is the function of the courts? We said we have three branches of government: legislative, executive, and the judiciary. What was the function of the judiciary compared to the police? We said they are responsible for administering the law. What does it mean to administer the law in these circumstances? Who is more knowledgeable about what needs to be included in this act or not? Is it someone like the minister responsible for this portfolio, or is it the courts? What kind of qualifications do the judges have? Are they simply, well, where do judges come from? They are lawyers, or they started as lawyers. So what's their education? What is their training? Do you think that they are in a position to understand, how these stock routes would work, and how important they are, and whether they should be excluded or not? So what do we usually do in those circumstances? The court could either defer to the parliament or to the executive. So they would say, we're not going to look at this because we don't have the expertise. You decide. Or they could bring what? Someone who's an expert, and then you'll have the hired guns battle. So I bring an expert, you bring an expert, our experts try to influence the court's decision. There's no right or wrong answer, of course. This is put there just for us to be able to think a little bit more about what we read and whether we agree with it or not. So again, we apply, as always, our analysis. The parties were the council and the attorney general. Objectives: council wants to claim the land. HMP, that should be AG. AG says excluded. Or something like land excluded. Then, what are the premises? So now we talk about the act itself. The council is relying on the act, relying on sections 11 and 12, relying on the speech by the minister. They don't need anything else. The AG has to try to influence the court by saying the exclusion of roads over which the public had a right of way is part of, or like stock routes are caught by the same sections 11 and 12. So the issue is a stock route or road over which the public has a right of way. The law is about interpretation. So the Act's interpretation acts. It says interpretation of excluded roads using the minister's second reading speech, i.e. external evidence, extrinsic evidence. And the ratio basically here is that exception in these sections did not intend to pick up the network of stock routes. All right. That brings us to the end of our colloquy, and we'll start then after maybe a 15-minute break on our tutorial. The tutorial is going to take a bit longer because we're going to do our assignment, so we'll take it nice and slow, and part of it is going to be theory on alternative dispute resolution. See you in 10 minutes. So let's start at 9:05, please. All right, so welcome back. And I just want to start with something that someone pointed out earlier. And if you go to quizzes, on the left-hand side, there's a quizzes tab. And it comes up with this table here. And as you can see, it gives you dates that say quiz closes. And the question was, how come the quiz for the assignment closes on the 19th of September at midnight, 5 minutes to midnight, although we said that it's going to be due on the, I think 18th, was it, of August. So usually I leave it open just in case someone actually needs an extension. But if you don't have an extension and you submit after the due date, you will be penalized per the schedule for this university. So I think it's what, 5% or something per day or something. So the due date, the correct due date is what we talked about. That's our contract. So again, these are the assessments and these are the due dates. So the assignment is due 5 minutes to midnight on the 18th of August. Please note that the online quizzes i.e. online tests 1 and 2, are due at 6 p.m., not at midnight. 6 p.m. on the 4th of August, 6 p.m. on the 20th of October. Why is that? Why would I want to have that due on the, at 6 p.m. and the other one I just left 5 minutes before midnight? What's so special about that? This is why. The other two are automated. The tests are automated. No one is marking. Once you finish the marking and you are over the due date, you can now look at the answers and look at your marks. I don't want you to wait until midnight to do so. So once you just submit after 6 p.m., go have dinner, whatever, come back, you'll find your answers and you'll find your results. Just remember, it's not midnight.